many thanks for joining us today, and thank you so much, because I know you're very busy, clearly, with thousands of claimants now that have joined on to this class action that we're going to talk about. It'd be quite good just to get a bit of a glimpse of the types of work that you deal with.
I actually started out as a journalist, so I then went into media law, and I did lots of defamation, privacy type of disputes. And then I found that, like all litigators, I was doing more and more commercial matters as well. But I always kept that side of my practice going. So I qualified nearly 20 years ago now, and I trained at what would call itself the leading media litigation firm. And over that period, I did lots and lots of data things, for instance. So I, over time, did group data actions. And then with the GDPR, I've sort of had a bit of an explosion with my caseload of large scale data privacy group and class actions. And alongside that, as I was mentioning, I've always done sort of my contract type cases, and student group claim came along, which wasn't an automatic home for me in my caseload. But it's been absolutely fascinating to work on, and that's effectively a breach of contract matter that's taking up an awful lot of my time at the moment, and it's really rewarding and really interesting.
Fantastic. And we're going to talk about that in just a moment. Thank you so much for a bit of an insight there, Ryan, into the types of work that you deal with. So can I start off by asking you, actually, can you tell us a little about Student Claim Group?
Yeah, no, effectively what happened was students who were affected by lockdowns and strikes petitioned their universities and said, well, it's completely unfair, obviously, for them to pay full fees. And then, for instance, in that year, I think it was the academic year 2020 to 2021, to be sent home and told that it was going to be online, and the universities had to very much rush together how they were doing the teaching. So the students themselves complained at first, but they didn't feel that it was being resolved in the way that they wanted. So we got about 2,000 or 3,000 who came to us, and we wrote a letter to University College London on behalf of 3,000 students in April 2022. It promptly denied all liability to pay any compensation whatsoever towards students, which we're saying is unlawful, because effectively they contracted to provide in-person tuition and access to physical facilities, which they couldn't do during lockdown, which nobody's disputing, but they shouldn't have charged full fees, just like independent schools. They gave discounts, as did every other business in this sort of situation, gave a discount. But for some reason, universities thought they were exempt. So we started to pursue it on behalf of about 3,000 students in April of last year, and now we've had 150,000 students approach us in relation to 160 plus, I believe, universities now, and we're looking to pursue all of them in group cases if they won't settle for any sort of reasonable terms. And so far, every single university has denied all liability to pay any compensation whatsoever to our clients. Which we think is an outrageous position to take. We think it's legally wrong. I mean, obviously, we've had expert counsel look at this. It's not just me as a solicitor who's a commercial litigator of 20 years. We've also, 3 King's Counsel in this area have looked at this, as well as junior barristers. And we have obviously lots of very accomplished lawyers at the firm. And it seems to us to be an untenable position for the university simply to say, what else could we have done? We did everything we could in the circumstances, which resulted in us taking full fees from the students and not providing what we contracted to provide.
Sure. Now, in July of this year, the High Court decided to pause the claim to enable the parties to effectively engage in alternative dispute resolution. There was much talk about using the internal complaints procedure and the Ombudsman, but the court found that given the volume of the claimants, I understand, it would be far too much for the universities to deal with. And so at this moment in time, we understand that the claim is paused. Can you tell our audiences as to what the status is, without going into anything confidential, of course, and what that means for students at this stage?
Well, just to clarify about what the court said back in, I think it was July the 17th of this year, it effectively said, you're right, it has reservations about using the internal complaints procedures of the universities and then the Ombudsman Service, which is what, up until that date, UCL, which was the defendant in our lead case, had been saying that our students had to do. Now, if you look at that, it's such a logical position for the judge to have taken, because the Ombudsman has never dealt with even 3,000 claims against all universities in the country in 1 year, and we have 150,000 potential claims here. So how that could work, I don't know. But yes, proceedings have been paused in the UCL case with a view to the two sides bashing their heads together and trying to get an out-of-court settlement. And we can apply to lift that stay on the 17th of November. And it can be extended until effectively the 17th of May, when it will automatically be lifted as well if we don't make that application. So yeah, we very much hope that that UCL does settle this on reasonable terms, and that will also set a marker for those 160 plus other universities to also settle, because the principles are the same. And like I was saying, essentially the universities either have an implied or an express term to provide in-person tuition and access to physical facilities. And even if they have something in their terms trying to wriggle out of this, hidden somewhere in the depth of what is often very difficult contracts to read, particularly as they sort of cross-reference with other documents, and we're talking about, on the whole, 18-year-olds being expected to read all of this, we say that under consumer legislation, it would be unfair to try to rely upon any such terms. So they're all essentially in the same position. And we're not saying the students should be repaid their entire fees. There was some tuition, obviously, that went on, but it should reflect what was provided. And quite frankly, in that main COVID year, the students could have gone to the Open University and actually had a online distance learning course taught to them, which was designed for distance learning, whereas these other universities had to effectively cobble together something at very short notice that I would say was of a much lesser standard than the Open University. So they should be paid at least the difference between, say, an online course and an in-person course. And these universities, some of them did actually offer the same course online as in person, and it was always cheaper to do it online. So for them to think they can just keep the full fee, it's outrageous, in my opinion.
Absolutely. Just in relation to what you've mentioned there, Ryan, in terms of the measure of loss, now what that means in simple terms for our audience is how much a student will be able to recover. I'm not sure if it's something that you're able to comment on at this stage. I suppose there are Open University courses, which of course students have looked at, I've looked at as well, which are comparatively cheaper. Is that something that the claimants or yourself, you're looking at for the purposes of measuring how much compensation a student could, on average, be owed?
Partly. So sort of yes and no, I suppose, is the answer. We'll almost certainly need expert evidence to be provided to the court to explain this, because it is fairly complicated. What value was the actual course that was provided, not what was the value of what the course that was promised, which we know is the fees that were paid. And there's also a difference between international students. I mean, some international students were paying £30,000-40,000 a year, whereas a UK student was paying £9,250 for the same course. So, there's an argument that the international students should be paid more, because obviously the difference between 30,000-40,000 and what was actually provided is going to be greater. So all of this needs to be fleshed out. What we've been saying to students, and I think this is actually on the conservative side, is we're looking at about sort of £5,000 a head. But this isn't a totally accurate assessment, because, like I was saying, international students and domestic students are paid differing amounts. And some people weren't there during the COVID year, so they were affected by strikes. I mean, if you think about it, I think it was 2020, 2021 when universities effectively just sort of shut up shop and told everyone to work from their bedrooms because of COVID.
Yes.
Those students are probably going to have higher claims than those not affected by that. But if you think about that year, if you started in that year, so you had all your teaching from your bedroom for the year. The next year was full of strikes, while the universities were effectively dealing with very disgruntled staff. And also the universities over this period took on loads more students, because it's very cynical, but I think they realized that by going online, they weren't restricted by the amount of people you can fit in a lecture theatre. So you say you could fit 1,000 people in a lecture theatre, you can fit an infinite amount of people on a Zoom call. So some of the universities actually increased their student numbers by 50%, incredible amounts. And the tuition fee revenue is as a result of that. So when COVID finished, the university didn't rush back to in-person teaching, but they were still advertising their services on the basis of, come to our historic university, be taught by our amazing professors and lecturers. We've been around for this many years and we have the most incredible library and facilities. And then the students were getting there after the COVID period, and the universities on the whole, certainly anecdotally, at least from the students who've approached us, the universities were saying, well, yes, we have this thing called hybrid learning now, which was turning out to be a lot like actual online learning rather than hybrid learning. And we still seem to be stuck in that. So the students had, like I say, if they joined the university in I think it was September 2020, they would have had a year of basically lockdown tuition. Then they would have had that cobbled together, messed up hybrid tuition, which was largely online, and strikes where they just weren't being taught at all. And then the following year, the same. And now they're looking to graduate, and some of them can't even get their degree certificates. And the universities are saying, "Oh well, we performed exactly the service we were contracted to provide, and so we're not giving you any sort of a refund." It's disgusting, quite frankly, and outrageous.
Yes, absolutely. And what would you say to the students who believe are eligible for compensation? I suppose that applies to everybody now across the board, anybody that's gone through the trajectory that you've just mentioned and the experience that you've just mentioned. What should they do, Ryan?
Well, they're not alone. They can come to us. They can look on our website, studentgroupclaim.co.uk. There's an awful lot of information on there, and they're free to join and to contact us as well. So if they do join, and even if they don't, there are all sorts of contact details on there, and we have a large team of people who are lawyers here who are quite happy to talk to them. So if they're eligible, they can join the case and add their name to it, and we will process them and seek to get compensation on their behalf, like all the other students who've come to us so far.
Fantastic. We're going to have the link to student claim group in the description. So anybody that wants to go ahead and reach out to the team, please do click on that link. May I ask you, Ryan, just in relation to that, so it doesn't just apply to former students, it's also current students, isn't it?
Yes, although as things sort of progress, then people are less likely to have been affected by that COVID year, which is the main year. So we're not looking, for instance, at the marking boycott because partly because we issued the claim against UCL before that travesty was imposed upon students by universities. There's only so far we can take these things, and actually there's an awful lot going on here. Yeah. So yeah, they could be current students, but they're more likely to be, say, postgraduate students at the moment, because a lot of the ones who were affected by that COVID year, if they were undergraduates, will have graduated by now and be in their first job and possibly be saying, sorry, I don't have a degree certificate and I'm really struggling to work out what's going on because I wasn't actually taught what I was supposed to have been taught during my first year. I mean, we've got some students who, I've got one who approached us who's quite happy to go on the record, who's sort of said it before, who she was supposed to be taught how to do some crime scene investigations, and then she was going for job interviews at the end of her degree, and having to fess up and to say, look, I can't try to mislead you. I literally haven't been on any sort of fake crime scenes at universities or anything. I've been pretending that my bedroom's a crime scene, and that I can, I can extrapolate from that what it would be like universities have set up facility to mimic a crime scene, and they've basically said, well, I've had to sort of, my employers have realized that I've had to catch up on all this in the job, and then this must be affecting people's salaries and their marketability, which it's not, again, there's awful lot of complexity here. That's not part of what our claim is, because that's a whole other argument that students could bring forward, where we're seeking what's called performance interest damages, which is just very simple. You promised one thing, you delivered another, you deserve to be paid the difference in value between what you were promised and what was delivered. But there is also, they are financially affected by going into the job market and employers realizing that they haven't been provided with the tuition that they were promised, or that was given to students in previous years, and that it's completely unfair, and that is going to impact them in their jobs, and also for postgraduate courses for the people who haven't even had a mark, for their undergraduate degrees, say. So there are all sorts of aspects to this that make it incredibly unfair.
But all very interesting, actually, hearing about it, Ryan. All very interesting. Although I'm sure it's a lot of work for you, given that it's now 150,000 claimants. It's quite a number. And so what's next in litigation? Let's say 8 months later. There's no settlement. You're now applying to lift the stay and sort of get into the trial. What does that look like? How long do you think this perhaps might take until we have something in terms of a judgment, let's say?
Well, it'll probably be a split trial because we have that sort of thorny issue of exactly how to calculate the compensation has never been done for this sort of thing before. So the stay will be automatically lifted on the 17th of March. And then we will be trying to push ahead as quickly as possible to get a trial on liability. And after that, I feel that the universities, I mean, who knows, but, they'd be pretty mad not to settle it if we win on liability, because then it's just a case of how much. And then they need to start actually talking to us about how much and, what the difference in value is, and trying to break it down with us. We've, I've got to be careful about confidentiality, but, we've done everything we can to try to bridge that gap with them, to talk to them and say, we think, this is what we should be talking about. But, it requires two to tango, basically. So we should have a judgment, I feel, at the end of next year or fairly early, the beginning of the following one. I mean, I realize that's sort of a disappointingly long period of time, but, that is just how the system works, and we'll be pushing to do it as quickly as possible. And if people don't sign up to it, then they don't get any compensation with our case. I mean, I don't know if they'd bring their own case or whatever, but so it's in their interest to actually sort of sign up and join the list of students who we can actually push this ahead for. So in terms of timings, we've got to decide whether to apply to lift the stay on the 17th of November, which we can do. It might, that might be the end of the stay. Or whether there is some sort of progress that means we can wait until at least the 17th of March, and if there isn't progress, then push ahead with the trial. But like I say, probably the end of 2024, possibly the first part of 2025. But then you're also discounting the fact that maybe it's going to settle. Maybe we do have the stay period of up to the 17th of March. We want it to settle. I mean, we've had an argument leveled at us, which I think is quite hilarious, by University College London, where it's sort of saying, we're sort of stringing things out, and, we're lawyers. We just want to make more money by stringing things out. Well, firstly, their bill was much higher than ours for the last hearing, which the judge quite rightly pointed out. And secondly, we're on a no-win, no-fee deal where we get paid the same whenever it settles.
Yeah,
so
yeah.
what is the incentive for us to string this out for a year and a half? There is zero incentive. So that seems to have been not really grasped by the opposition. But there really is no incentive. We want to settle it as soon as possible. We want to settle UCL, and then we want to settle all the other ones, because we think that the principles are the same, and we would like to see the students get paid this money as soon as possible, and for the whole thing to conclude.
Absolutely. Well, thank you very much indeed. We wish you all the best, and we'll be watching eagerly, Ryan, waiting for that judgment to come through. You're making history, actually. This is the first time that this is happening. It's unprecedented for a group of uni students to take action against universities. So it's unprecedented. You're making history, and we can't wait until you get that judgment.
Thank you very much.
Thank you so much for joining us, Ryan.
Thank you.